3161. Hey, can you start me one more? I got a vehicle over here that fled from me the other day. He's in the parking lot.
Yeah, 4. Get somebody else over there. 3230, go inside that way over there with 3161. Gonna be off of 11 to the 100, blank over to the McDonald's. And 3161, you want him running code?
10-4. License plate. Get out of the car. What? Shots fired! Shots fired! Shots fired!
Earlier, you got a return on it right now.
Shots fired! Shots fired!
For shots fired on 3161, 11 to 100, Blanco Road, code 320. 3160, go ahead, that way, 3101 on the over there.
All right. Court is calling 2024 CR 1238 and 2024 CR 1237, State versus Erik Nathaniel Cantu. And are you Mr. Cantu?
Yes.
All right. All right. And each of the cause numbers, are you the same Erik Cantu who was placed on deferred adjudication in cause number 2024 CR 1238 for the offense of evading arrest detention with a vehicle on September 9th, 2024 for a period of 7 years. Is that you? All right, State.
Your Honor, we are going to proceed on the only allegation named in the NPR.
All right. Would you like to read it into the record?
I will, Your Honor. I'm just trying to find a copy of it. On or about the 28th day of September 2024 in Bexar County, Texas, the defendant Erik Cantu committed the offense of assault in violation of condition number 1.
To that offense, how do you plead? True or not true?
Yeah, it's true.
And that is in both cause numbers?
Right.
All right. Then the court will find violation of condition number 1 true. You may be seated. So, to both parties, the defendant was placed on deferred adjudication on September 9th, 2024 for a period of 7 years. The new number 1 that is listed in the allegation is from September 28th, 2024. We are currently sitting at November 11th, 2025. So the court's question is, this new number 1 that is in the motion to revoke that the defendant has pled true to, why is this just not being brought at this late date? And the court will note that the motion to enter adjudication of guilt was filed on September 23rd, 2025. So you have something where the defendant has pled true from September 28, 2024. And this motion to revoke was just filed on September 23rd, 2025.
Yes, Your Honor.
Yes.
Your Honor, as I have explained, when I was assigned to this court, I reviewed a motion to potentially consider withdrawing Mr. Cantu's GPS. And upon doing so, I observed that he had this unfiled misdemeanor assault that had viability to it. I can't explain why the case sat for as long as it did. I just know that as an at-large filing, a lot of times those cases don't get looked at as quickly as arrest cases or people who are sitting in jail. So when I looked at it and I saw that there was viability to it and a cooperative complainant with legitimate injuries, it was not something that I could just ignore. So therefore, upon reviewing the case and talking with the misdemeanor prosecutor, it was decided that the case should be filed and it had to be addressed. It could not just be ignored. It had to be addressed because it did occur after he was placed on probation. Respectfully, if we had known about this and had the opportunity to evaluate it and understand the allegation coming from the complainant in regards to what Mr. Cantu has just pled true to, if we had an opportunity to understand all of that earlier on, we would have recommended revocation earlier on. And I apologize that it took this long for it to happen. I understand that that is not ideal, but with a victim who had legitimate injuries and legitimate trauma from what happened, it was not something that we could just ignore and say, oh, it's been so long, so it shouldn't be addressed. He violated his probation 2 weeks after he was placed on probation by violently assaulting a young woman.
And here's the problem. The problem is that he has been on deferred adjudication for over a year, and there is this file that's just sitting upstairs. So how many at-large cases that are, and I'm assuming this was a family violence case?
It's not, Your Honor.
Oh, it's not?
No.
So how many cases are just sitting up there, haven't been indicted, and nothing has been done with them?
Your Honor, I don't know. I wish I could tell you. I don't know. I know that the subject of the backlog has been a regular subject of discussion. I can't explain it. I would love to be able to give the court a better answer than that. All I know is when I got put in this court and when it got put on my radar, I saw that it needed to be addressed.
I can tell both parties what the court's problem is. Whoever radar it was put on, when it was put on, the court's problem is that this case was only recently filed in September of 2025, and he's been on probation since September 2024, and nobody does any with regards to this case that's just floating out there.
Your Honor, what I can say, and I'm not saying that it's going to make everything okay, but what I can say is that, as the court is aware, he was placed on probation in early September of 2024. The offense date for what he's just pled true to is September 28th of 2024. Mm-hmm. He picked up his very first MTR in October of 2024, which was only a month after having been placed on probation. Mm-hmm. But our office didn't know about these allegations because they weren't even filed with our office until December 18th of 2024. So when that first MTR was filed and disposed of in December, on December 4th of 2024, we still didn't know that this case existed. So the MTR got disposed of, he got sent to ISF. And then once he is sentenced on his MTR and the MTR is no longer pending, we have no reason to look him up and see what else is going on until he is set on our court date or in court for us. And since the misdemeanor case was an at-large filing, he never got a court date on it. So we were never notified that he had a new case. And if we don't know he has a new case, then we aren't going to be looking him up to see what's going on with him because he's already been sentenced on the MTR. And that part has already been closed out.
But this was sitting in your office, you say, since December 2024?
There was the JN was requested by the police department December 18th of 2024. Okay. I'm not entirely sure when the case was completely sent over, but that's when the JN was requested. Yes, ma'am.
Defense, do you want to address those issues?
I would, Judge. And I will start with the comment. It was brought to my attention when there was a request made for him to have his GPS removed. And that request was made by the probation department. So the probation department at that time has found that my client has been such a model probationer that on their own, they asked the district attorney's office to review the possibility of removing the GPS monitor. And only at that point did the state then realize, well, no, not only will we not agree to that, we're going to do something completely opposite. We're going to file a motion to revoke his probation. And based on a case that was filed with the district attorney's office, according to the charge and disposition report, December the 18th of 2024. So for the district attorney's office to say, hey, it's not our fault because nobody told us, it's their own office. So what you have is a young man who was placed on probation September of 2024, has pled true to this offense that happened several weeks after, came before this court in October of 2024, and this court took it upon itself to sanction him, send him to ISF, has had him on the monitor since then. And I think what perhaps the most important, or one of the most important things to consider is how he's done from that point until now. And that's in the court summary, which I certainly hope the court has had a chance to review.
I don't review court summaries until there are no objections. Any objections to the court reviewing the court summary?
No, Your Honor.
And do you have a copy, or may I approach and tender a copy to the court?
Usually it's emailed to me, but as I said, I don't look at any of this until both parties have no objection. So let me see my email. All right, I do not have the court summary.
May I approach?
Oh, you know what? Actually, it is here. I'm sorry. It was thank you, Ms. Abrams. It was the last attachment. All right, just let me review this. All right, you may proceed.
I certainly think anytime the court is considering a motion to revoke probation, the court should always look to the person that knows the probationer best. And in this particular situation, that would be the probation department, who has, at the direction of this court, made upwards of 11 home visits, monitored him closely, and has made a recommendation to continue, and has justified their recommendation with what I would consider a lengthy justification based on behavior that has shown him to be an individual that, when he was before the court in October on the MTR, took the court's words to heart, went to the ISF. When he was at the ISF, was a model performer there, came out and has learned and performed, frankly, magnificently on probation. So not only do you look at how long ago this was and the fact that the state, for whatever reason, chose not to file the MTR on their own, and then also look at, well, probation knowing what the new number one is, because clearly they do, but more than Ms. Albin, the probation department knows Mr. Cantu. Knowing what the allegation is, it's still their recommendation to continue him on probation. And they justify this based on his behavior and his performance with the probation department. And I certainly think the court is aware that if probation had a concern about his ability to perform, or a concern about his ability to be a good probationer, they would voice it, and you would see it in this report. But to the contrary, this might be the most glowing court summary I've seen in quite a while for someone. And I think that's certainly something I hope the court will consider. So I'm certainly concerned that there's this belief that, well, it was filed in December, but nobody told me, so I didn't do anything about it. Well, they're the same office. So, and I guess we should assume that if the probation department had not on their own asked to have the GPS removed, we wouldn't be here, because the left hand is not telling the right hand what's going on. She certainly wouldn't have on her own looked up who Erik Cantu was, and we wouldn't be here at all. We're only here because he was doing so well, they asked her to consider taking the monitor off. That's the only reason we even got here. And if Ms. Albin is concerned that he needs to be prosecuted for this assault, that case is pending in a misdemeanor court. It's a misdemeanor offense. He has a court date coming up, and he will face prosecution, and is facing prosecution on that case. But to ask this court to revoke him for something that happened right after he was placed on probation, and more importantly, before he had the chance to prove to the probation, and more importantly to this honorable court, how he took this court's instruction and concerns to heart, and has proven to the court that he did listen to you that day in October when he was here in 2024. And it's indicative from the report. So I don't see how the court, I hope that the court doesn't justify revocation on something that happened over a year ago, before he had the opportunities the court gave him to improve himself and learn that where he was in a bad place. And the court is aware of the trauma that Mr. Cantu was facing then. Certainly he was the victim of a terrible, terrible situation at the hands of San Antonio Police Department. And I think, I know that the court talked to him about that on that day. They spoke about you and he spoke about it frankly, as I recall. And he took those words to heart. And I think that this justification by the probation department tells the court that he did listen, and he is taking probation very seriously. And I just don't believe that it's right for the court at this time to consider revocation for something that the only reason is we just didn't know it was there, when we know from the charge and disposition report, this thing was filed with the district attorney's office December 18th of 2024. That's not when the JM was requested. That's when the C&D was filed. So their office had it. And just, it's unfortunate. I mean, it's just not, I don't think that's the way things should happen. I disagree with Ms. Albin that There was not an opportunity prior to September the 28th of 2025 for anybody to do something, 22nd of 2025. So I'm asking the court to listen to the individuals who know my client the best regarding his probation, and that would be the probation department. I ask you to follow their recommendations, continue to monitor. I ask you to read closely the justification they give you for why they're recommending that. And I'd ask you to deny the state's motion to revoke. Thank you.
Thank you.
May I respond to him?
Just a moment. So this is what I want both parties to know. The defendant was placed on deferred adjudication. He came to the court on a motion to revoke. With regards to the motion to revoke, both the state and the defense at that time and probation asked the court not to revoke. They asked the court to deny and alter and amend and give certain conditions. Whenever I set conditions, I'm setting those conditions, hopefully so someone will turn their life around, hopefully so one will succeed. Some people always say my conditions are too many, but I provide people with conditions that are supposed to make them think about the reasons they're here, internalize it, and do better. Now, what I'm looking at, since that motion to revoke has been filed, that the court sentenced him to ISF, he successfully completed it. The court keeps him on GPS, so he's still on GPS. I ordered that he complete parenting class. According to the court summary, he completed that. There was a request for him to take the aggressive driving course. He completed that. The court has placed an order that he's not to drive. I haven't received any information since that first motion to revoke that he is driving. The court ordered him to provide proof of employment. And as both parties know, that's normally no employment as a home healthcare provider or with minors. And based upon what I'm seeing here, he has completed that. And probation is recommending that he not be revoked, that he be continued to be monitored. And the fact that I have this case here and another judge just had me, and it's, I should say justice now, Justice Velia Mesa, asked one of her students to send me questions, sort of an interview, and to answer those questions. And the first question was, how do you as a judge deal with cases where there's publicity involved, right? And I wanted to send them a simple answer, but then I'm like, they probably wanted more detail about the judicial canons of ethics and all of that. But for the court, I don't take publicity in any consideration because I'm supposed to be objective. I'm supposed to be fair. I'm supposed to listen to both sides and make a decision on whether or not someone should be revoked or not revoked. So I want both parties to know that I don't consider whether a case is publicized or not. I just listen to whatever is presented to me and I make a decision based upon the evidence that's presented to me. And with regards to motions to revoke, whether or not I revoke someone after a finding of true, that's really within the court's discretion. And State, my understanding, you wanted to respond?
I just wanted to say a few things in response
Sure.
to what Mr. Bunk said. Mr. Bunk said that probation is basically describing his client as a model probationer. And I don't disagree that they are saying he's been doing well since his first MTR.
Yes.
But they don't know the extent of what he did to Janie Lopez.
Mhm.
Nobody knows the extent of what he did to her except for her and the prosecutors that have been working on it now. And she deserves her justice as well. And so that is, while it is true that he has been doing better, I'm not saying that he hasn't. That doesn't negate what he did. And for Mr. Bunk to say that we wouldn't be here if they didn't put a GPS removal in front of me, we maybe wouldn't have gotten here as fast. But when the misdemeanor case got filed, that generally triggers a motion to revoke. So I think that it's very likely we would have gotten here maybe a little later because Ms. Lopez is cooperative and does want him held accountable for what he did to her.
And let me ask you this. When is the first time that the district attorney's office reached out to the complainant in that case?
The first time I saw a note about it was August of 2024.
All right, August 2024.
Yes, ma'am.
And I'm assuming that when the case came to the state, it would have had the complainant's name and the accused name, and nobody did anything. Everybody just let it stay there. And I understand that it's not you. And I want the record to be clear. I understand that prosecutors who are in court, normally they're not indicting the case. They just end up with the case that's been indicted. I know that's why sometimes there's certain discovery that maybe you would want to be in the file is not in the file because you didn't indict it. And I know that you are not the prosecutor who looked into the case from 2024 with this complainant. I know none of the prosecutors in this court looked into this case with the complainant from 2024. So I understand, and the court is not blaming you for any of that.
I understand your.
Okay. So to the complainant, I understand that, and I have to be careful what I say because of the legal rules, right?
Sure. And I'm sorry to interrupt, Your Honor. I believe that our victim, Ms. Lopez, has actually stepped outside.
Okay.
Just so you know.
So I understand with regards to the complainant that it would have been great for them and better for them if this case would have been addressed when it happened, anytime in the year of 2024. But that hasn't happened. And I have to look at cases objectively, and objectively, should he receive some sort of punishment in this case for that? Yes. But should it be a revocation? I don't think so. So, Mr. Cantu, sometimes I can give people choices. Sometimes I cannot give them choices. Here are your choices, and you only have two. Don't ask me for a third. Number one, you will be found guilty on these cases because whether or not the state waited so late to file this or not, it should have been filed. You know that. I think your attorneys know that, and the state knows that. So I will find you guilty. I will continue you. You'll continue on your GPS. Do not ask me to remove that GPS. And I will sentence you with an underline of 10 years and place you on probation for 8. Or I will revoke you on both of these cases, run them concurrent, because legally I must run them concurrent, and I will sentence you to 4 years in the prison. Do you want to talk to that with your attorneys? Counsel, you want to speak to him about that?
Yes.
Yes.
We're prepared to take the, what you said, 10/8. I think that's what you said.
Yes.
That's fine.
All right. And each cause number, this is what the court will do. And Mr. Cantu, I want to let you know you're being found guilty because you should receive some form of punishment for that violation. And one of the only reasons why you're not in prison with regards to this violation is because the state waited a whole year to file it. You understand? It's because of that and because of the probation's report that you've been doing well. All right. So in each cause number, the court is going to find you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. So what that means with that 10-year sentence is that if there are violations on this motion to revoke, you're looking at potentially 10 years in the prison. Do you understand?
Yeah.
And has the probation, has the restitution been paid or no? And has the also has the fine been paid?
I don't have a restitution amount listed.
All right, we'll need to set this for a hearing then to make sure if there's any restitution that is paid. Ms. Ferguson, I need a date in the last week we're here in December for a restitution hearing, and that's in regards to Tiffany Johnson and Walmart.
Your Honor,
Yes.
may I make a request?
Yes.
Obviously at your discretion. Since he has pled true and you found it true, could we order restitution and some conditions relevant to the assault allegation?
Yes, if you all will, what we'll have to do is we'll have to have a hearing on that. So, Ms. Ferguson, a restitution hearing, please. All right, so we're going to do on December 15th and state on that date, whatever conditions you believe would be appropriate, I'll have you all confer, and there may be additional conditions for your client.
Okay.
Judge, and to be clear, that restitution hearing is under the clause number 1238, ending in 1238.
Yes.
Thank you.
All right. And then probation, it'll be all previous conditions. Do you need me to recite those again?
No, Judge, I do need clarification on one condition. He was placed into the ISP program, which is our intensive supervision program, on 5/13/25 upon completion of the local ISF.
Mhm.
And he was due to discharge on that program on September the 9th. Do you still want him to remain in the program?
Yes. And state, what is the cause number for the misdemeanor?
Give me 1 second, Your Honor. I have the file right here.
And there's to be no contact with the complainant in that cause number. And the no driving still stands. Oh, and I just need the cause number.
Oh, yes, it is. Okay. 2025 013069.
All right, and there's to be no contact with the complainant in that cause number 2025 CC 013069. All previous conditions are to remain in effect.
Just so that I'm fully aware, the GPS, I believe it's partial
For employment,
for employment only
yes,
And his
medical.
medical funds.
yes. Right. And then in cause number 2024 CR 1237, the court is going to find you guilty. And in that cause number, the court will sentence you to 10 years in the prison, suspended and probated for 8 years. And all previous conditions are to remain in effect. And there's to be no contact with the complainant in 2025 CC 013069. So that both parties are clear, we're going to come back on December 15th. At that time, state if you will have the documentation on any amount of restitution due to the complainant in 2025 CC 013069. And at that time, the court will consider any amendment of the conditions that the court has previously stated.
Yes, ma'am.
And Mr. Cantu, defense, I think.
I just did one, Judge. You probably need a second.
Yes.
Yeah, as you were saying that, I realized I didn't.
And that's the 37 number.
Yes.
In each of these cause numbers, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? Mr. Bach, there you are. Thank you. Is there anything else before we go off the record?
Not from the state, Your Honor.
Not from the defense.
All right, thank you.
Cold hallways whisper of lives you forsake. Your gavel's a toy, lightweight, when justice aches. You dodge accountability under marble and cloak, slashing habitual like bargains at some charity hoax. Peddling plea deals, community foots the bill. 2 peas in a pod, you and the DA trading lives for your thrill. Mercy by decree, but victims drown in broken trust. You preach reform while feeding your own ego's lust. Don't rock the boat, you'd rather watch it leave. Your mercy's a mirage, your verdicts are weak. Behind that alabaster throne, you smile at despair while real people collapse. Your absence from the cage. You're a weak ass judge, puppet to powers a whim, missing felonies so your ego can brim. Your social worker complex, starving real respect. Community safety, just collateral you neglect. You feed headlines with excuses, rinse and repeat. But justice ain't a show, stop playing for seeds. You wave enhancements like they're party favors, reducing felonies, rewriting the lifesaver. Your bench is a stage, Act 1 But behind each truck, there's another promise betrayed. You coddle repeat offenders, ignore the next crime, counting your kindness while lives slip through time. Statutes bent to fit your hollow PR spin. You claim compassion, where does the change begin? Your robes are badges for moral decay. You lecture on reform, then send the guilty away. Sympathy's a currency you spend with no thought, leaving victims to gather the pieces you forgot. You're a weak-ass judge, puppet to power's whim, missing felony so your ego can brim. Your social worker complex, starving real respect, community safety, just collateral you neglect. You feed headlines with excuses, rinse and repeat, but justice ain't a show. Stop playing for seed. High tide of ego, we watch the shorelines drown. Your mercy's a flood that buries every town. We spit truth in that hollow cathedral dome, expose the soft lies beneath your alabaster throne. When the gavel hits silence, will you still stand tall, or crumble in the courtroom you built to enthrall? Victims' voices echo off those cold courtroom tiles. Your decisions ring hollow for countless miles. Behind closed doors, you swap power for praise, while families mourn in unending malaise. Every case you dismiss, every charge you drop, is a crack in the foundation. When will it stop? Accountability's a word you buried in the past, but truth has a pulse and justice bleeds fast. No more soft handed, no world craving steel. Your empty gestures can mask what's real. We're done with your pity, your patronizing tone. It's time to put down the gavel, face what you've sown. Weak-ass judge, puppet to power's whim, missing felony so your ego can brim. Your social worker complex, starving real respect, community safety, just collateral you neglect. You feed headlines with excuses, rinse and repeat, but justice ain't a show.